Time to check in with CoinDesk Global Policy and Regulation Managing Editor Nick Day, who's also the editor of CoinDesk, the State of Crypto newsletter. Good morning, Nick. Happy Friday. So the SEC must surrender an email with a draft of former Director William Hinman's speech on whether ETH is a security to Ripple. And you wrote an article on this story. So what's going on, Nick?
Good morning. Yeah, so last night, Magistrate Judge Sarah Netburn of the Southern District of New York ruled that the SEC has to turn over certain documents, including, as you said, a email of a draft of former Director of Corporation Finance William Hinman's speech, in which he said that Ether is not a security. This is it's a continuation of the procedural back and forth that we've seen over the past year. Literally, it's been more than 12 months at this point since this case began, and throughout this, what's really been happening so far is the two parties are just trying to kind of define the scope of the discovery process. So try to figure out, who has access to what. In last night's ruling, Judge Netburn said that, anything that, constitutes internal deliberations or, pre-decisional thoughts does not need to be turned over. It's protected by, privilege. The SEC can hold on to that. Anything that shows viewpoints of the authors rather than just, straight objective note-taking. So the SEC does have to turn over this email as well as certain communications between themselves and, Ripple in particular. It does not have to turn over, documents pertaining to, interagency communications. It does not have to turn over documents with other third parties. Basically anything that might kind of hint at how the SEC approached the enforcement action. So in addition to the email, that they do have to turn over, there's a separate email from the office of the counsel of the Director of Corp Fin that does not have to be turned over because it is more subjective than objective.
So let's step back a second here, and what's Ripple hoping to get out of this? Because the Hinman speech was, from my recollection, this was a while ago, was that it was kind of pivotal because it said, hey, you know what, this is not a security, and it sort of led to a little bit more comfort in people looking at ETH as an investment vehicle because they didn't have the worry of the SEC on top of it. So what is Ripple hoping to get out of having these notes, having this information out there?
Right. Yeah, you're exactly right. The Hinman speech ultimately, kind of can be traced to, we have Ether futures now. Ether's been, cited as a commodity by members of the CFTC. So, that speech was certainly pivotal, although it's worth noting that at the beginning of his speech, Hinman said that those were his own views and not the views of the SEC itself. And I mean, that's just kind of how the SEC operates. Everything is the views of the person saying them. So still pivotal, though. And I think what Ripple's looking for here is proof that either XRP and Ether are being treated, separately and distinctly by the SEC, despite similarities that they want to highlight, or that, the SEC's Ether stance, such as it is for whatever reason or however inaccurate, if you compare it to XRP status and the way the SEC has approached it. So, they're really just trying to highlight either, what they view as kind of a, unreasonable distinction between the two different assets, or the similarities and why they should be treated the same, i.e. not securities.
So do we know, behind the scenes, and I guess this is we're still waiting to have come out, whether or not, I don't want to say it was personal, but whether or not this was an incredible difference in just viewpoints within the SEC that ultimately led to this kind of, to this lawsuit. Do we have any sense yet as to how much personal opinions, not just Hinman's, but other commissioners had in making this happen?
So going off of my recollection of the last 2 or 3 years, really, 3 years. So the way Hinman approached Ether in his speech, he said that in his view, Ether at that moment in time was not a security because of what he claimed, what he said was the amount of decentralization, the number of parties involved in not only, using Ether, but in running nodes and distributing Ether. So, talking about the miners and talking about the different parties involved in, looking at the code and such. In his, in that same speech, he kind of implied that Ether might have been a security at launch, but that it had become, quote, sufficiently decentralized in the couple years since. The SEC's case against XRP and Ripple claims that, Ripple sold and continues to sell XRP as a centralized party, and it's doing so for the purposes of, raising not only funds for itself, but also promising that XRP's price will rise because of work that Ripple does or that Ripple, employees do. So, I can't speak to whether or not, this is like a personal thing or anything like that, but at least as far as the two different assets go, the SEC has, or SEC officials have drawn, kind of these distinctions in explaining, why they believe that Ripple is selling XRP as an unregistered security versus why, back in 2018, an SEC official said, yeah, okay, Ether is, not a security in my view.
Yeah, Nick, just stepping back, and we have to wrap, so we got to make it quick, but there's been a lot of talk about how the lack of regulatory clarity in the crypto space. We spoke to a Jones Day lawyer yesterday who just said, crypto firms have to find regulation through litigation these days. Do you think this is an example of that?
Yeah, I mean, regulation through enforcement has been kind of, what we've heard for years now out of the, attorneys who work with the SEC. And, put another way, you could say that that's just following the law or you're going to get sued. But the concern that attorneys have had is that, especially with digital assets, there are certain things that you can do with a digital asset that don't really map well onto existing securities law. And so what they're hoping is that the SEC will at some point go from just the enforcement actions to issuing, perhaps more binding guidance that attorneys can then point to and say, all right, if you do, this, and this, you're fine. You're not going to get sued. Good to go.